Our founders understood this. And yes, you know, there was some Enlightenment thinkers that talked about separation of powers, but you know what? Don't let them evict God from this discussion. Isaiah 33:22, for the Lord is our judge, the Lord is our lawgiver, the Lord is our king, executive, judicial, legislative branches of government. It is He who will save us. Again, we're not asking for a theocracy here. All we're asking for is an ethical foundation that informs our governance, and that we be allowed to use that ethical foundation when we govern. And for them to say that we cannot, that is nothing less than a bloodless coup. And I'm going to show you in the last few minutes that I have here how that bloodless coup occurred. The Supreme Court had a case before it. We had a clause called the Establishment Clause, and it was part of the First Amendment that is read along with the Free Exercise Clause, and it goes something like this: Congress shall not make a law respecting establishment of religion or prohibiting the free exercise of your religious conscience. So the founders had it right. It was a brilliant solution to religious persecution that was going on all through Europe. They said, we're not going to have a theocracy here. Lutherans, you don't get to control. Baptists, you don't get to control. Nobody gets to control and have an official government theocracy here. But at the same time, government, you are prohibited in any way from interfering with anybody's free exercise of their religious conscience here. It was brilliant. If you read the constitutional provision as it's written, it makes sense and it works. But if you hold a worldview and you have an agenda to remove the Christian worldview from the policy-making process, what do? Well, you find 5 lawyers wearing robes again. And you get them to say, well, maybe, you know, the word establishment doesn't mean establish. And that's exactly what they did. They rewrote the Constitution to say that any time the government acts, it must have a secular reason for doing so. It can only be informed by secular purposes. Now that's pretty scary. When I look at the Constitution that says, government, you can't establish a theocracy, and now the other side says, well, you know what, we're going to interpret that to mean something more. We're going to interpret that to mean that everything you do, government, must be informed only by a secular purpose. Let me show you how that works in closing here. Suppose a constituent comes into a state legislator's office and says, you know, I'm a physician. What's all this talk about physician-assisted suicide? A law like that would destroy the reputation of physicians. We are called to heal, not to kill. Will you please pass a law? The Hippocratic Oath says, I'm expressly not allowed to assist somebody in killing themselves. Will you please pass a law, legislator, that prohibits physicians from assisting in the killing of human beings during suicide? And the legislator said, sure, I'll do that. We'll protect the medical profession. We'll do that. And he writes the law. Now suppose a different legislator in a different state has a different constituent come into their office. And this time the constituent says, what's all this talk about physician-assisted suicide? All life has value. In the beginning, God created man and woman and saw what He created and said it was very good and said, I had a plan for your lives and said, I made man and woman in my very image. All life has so much inherent dignity that thou shalt not kill it. Will you please, because all life has this sacred value, will you please pass a law that prohibits physicians from assisting in the killing of human beings during suicide? And so the legislator says, I'll be happy to do so. And to save time, he wrote it exactly like his other legislator friend. So you've got 2 laws now. State 1 going up to the Supreme Court that prohibits physician-assisted suicide. Law number 2 prohibits physician-assisted suicide going up to the Supreme Court. They are identically written, word for word. Which law is considered constitutional, which one's not? The first one's considered constitutional because it's informed by a secular purpose, protecting the reputation of the medical profession. The second one is considered unconstitutional and unworthy of the rule of law because it was informed by a sacred purpose. They very effectively have removed us from the policy-making process. Now the good news is there's probably 5 justices sitting on the court that may no longer subscribe to that view. We need to make sure the next ones get appointed don't as well. But more importantly, we need to stop whispering. We need not to be ashamed from whence our ideas come, because they're truthful ideas. They're ideas that have changed the world for the better. They're the very ideas, like I said earlier, that ended slavery. They are the light in the darkness. If I shut this entire room down, in fact, why don't we do that? Can someone just shut the lights off really quick? Pretty dark in here, huh? Kind of a metaphor of what's happening in this world. But you see a little bit of light right here, don't you? The light will always pierce the darkness. Each one of you are a point of light. Turn the lights back on now. Each one of you are a point of light that can bring light into the legislative process or the judicial process or the local government process. My challenge to you is to have the convictions to do so, have the courage to do so, know that you have the power to do so because you are standing on truthful principles, not principles that change, every day or every month based on the whim of who's ever in power, but you're standing on truth that it was the truth before you were born and will be the truth long after you stop serving. Truth that we can always look to see whether our actions or our government is acting in a right or wrong way, a good or a bad way, or a just and an unjust way. Challenge for you is to, when you serve with that courage, serve with that conviction, and know that we serve a living Lord. And act like it. Hoorah. Act like it. I love you guys. Bless you.
Thank you. Talk to us about the founders' view of the judiciary. How did we get to this point in our present day where the judiciary is the final arbiter, the weapon of last resort for every single issue from the local to the Supreme Court, where everything, the judiciary is the final authority?
The founders' view of the judiciary was that it was to be the weakest branch, but they recognized the danger of it becoming a more powerful branch. And I would challenge you to Google or look up the Federalist 78. And if you look up Federalist 78, you'll get a very good understanding of what our founders' view of the judicial branch should be. Here's the thing. You saw what just happened we called it the same-sex marriage case. Folks, go read that opinion. That case, the smallest thing about that case was that it legalized same-sex marriage. The very first paragraph of that case, the Supreme Court did just the opposite of Federal 78 and exercised power in the ways that you're most concerned about. They literally ignored the Constitution and amended the Constitution to create a new liberty called the right of personal identity. Now, in the context of marriage and marriage laws, all marriage laws, like Michigan's Constitution, where 2.7 million or something people were participating in writing a truthful definition of marriage, that law had to now fail and go under the 5 lawyers' view instead because it interfered with all these individuals' new right of personal identity that they had now added to the Constitution. That particular decision was a coup, a bloodless coup. And the reason that it happened is the politically accountable branches of government, the government that is normally charged with making policy and changing public policy because they're politically accountable to you in the making of that policy, they didn't want to touch it. They were afraid of it. You notice that the court, and so the court, power abhors a vacuum. If there's anything you need to walk away from this room with from a political standpoint understanding is that power abhors a vacuum. If you don't exercise power, somebody will take it. And the court saw that the legislative branch and the executive branch were more than willing to give on this issue power away. So guess what? If you've got an issue that nobody's acting, they didn't take power to decide same-sex marriage. They said, I'm going to take power to decide who gets to decide. And from now on, we've got a Supreme Court that is basically holding that they have the power to wipe out the 10th Amendment. That it doesn't exist anymore. After you read that, if you read that decision correctly, if I read that decision correctly, the 10th Amendment no longer exists. Because under that Constitution that we were talking about, all power is given to the government from us. And we give it to the federal government in a very limited way. We say you can regulate commerce, you can raise taxes, you can make a post office. You can go down and read what their powers are. Very few of them. And it says all the rest of the power is reserved to the states, including making policies with regard to family and marriage, etc., which the state of Michigan and other states did. You can be for same-sex marriage and be very afraid of that opinion. Because the court said, nope, the 10th Amendment doesn't matter anymore, we get to decide. And they did. And so the founders viewed the role of the judiciary to be very limited, to decide disputes. The court, over the years, where the politically accountable branches let them do it, has increasingly taken more and more power for itself. Part of it is that these judges, they get on airplanes and do these junkets and they fly to Europe and they meet all these European judges where, the European judges have this power and they say, well, hey, I wear the same kind of robe you do, I'm going to have that power too. And so they take it for themselves with the ink of the pen, completely ignoring what the Constitution says. Now, it will only change if we, the people, put pressure on the representatives, or we, the people, become representatives and change it ourselves.
Our founders were brilliant people. They looked at history down through the years. They went back 700 years to develop our Declaration of Independence and Constitution. Today, we got politicians in black robes saying, oh, we don't know what the founders meant. In that case, all they got to do is read the Federalist Papers and they'll get a good idea. And they're saying, it's a living document. Well, they're right in that, because you can amend it. That's the only way you can interpret it. But my question is, why aren't we teaching? Why isn't it not a requirement in law school to have 3 or 4 courses of the Constitution?
What I would add to that question is, why aren't we teaching jurisprudence? Jurisprudence is the philosophical understanding and underpinnings of how we look at the Constitution. And so, unfortunately, where we are teaching it, you have professors that have adopted, again, this view that we are smarter, we're the experts, we know better than the general populace. And so they're teaching that that's okay. Now, I didn't do that, but I can tell you I was an extreme minority in doing it. Can we have some control over that? I suppose we do, especially in state schools where, again, your taxpayer dollars are funding that education. Think about it. And so you've got it exactly right. Sometimes when I get done talking, I say, oh my goodness, did I reach in? Did anybody connect? The fact that you've just articulated the way the judiciary is supposed to work, the way we're supposed to teach it, that's a huge blessing. Because if just a few of us walk away understanding that, hey, wow, there is a difference between a Darwinistic, evolutionary constitution where we get to make it up as we go along because we're lawyers and we're smarter than you are, versus no, it's a rule of law that doesn't change. It was there at the beginning of time, it'll be there at the end of the time, and we can use that standard. Do not interfere with religious conscience. Do not interfere with your freedom of speech. Give due process if you're going to take away somebody's liberty. We can look at those self-evident standards and measure our government conduct by those standards, and we don't get to change them just because we don't like them. One of the things that, in answer to your question more specific, one of the things that the other side has very effectively done that we need to be aware of is they've changed the notion of conduct and liberty. Liberty always is a limit on exercise of government power, right? We understand that. First Amendment is a limit on the exercise of government power. They can't pass a law saying that you can't speak about certain things. All right? Now, what they've done Because government has always properly been able to regulate unhealthy, dangerous, and immoral conduct, right? What if you want to engage in unhealthy and dangerous and immoral conduct and you don't want government to regulate you? Go find 5 lawyers wearing robes and say, will you please change that unhealthy, dangerous conduct, whether it is abortion, partial birth abortion, or sodomy, or whatever it is, whatever the dangerous, unhealthy, and immoral conduct is, you want to engage in it. What do? You go to a lawyer and say, you know, Judge, why don't we call it not conduct anymore, because government can regulate that kind of conduct. Let's call it liberty. And once it's called liberty, now guess what? Government can't do anything about it. Because now I have a liberty to engage in abortion and partial birth abortion, etc. The other thing they've done that we as conservatives should be very aware of is they do the opposite. If there is liberty out there that they don't want you to engage in, because remember, what does liberty do? Liberty stops government from interfering with your freedom of speech, for example. They take that liberty and they do just the opposite. They recharacterize it as dangerous conduct. And so that's why you're hearing things, laws about hate speech and contempt and all these other words that they use to pretend like they're not regulating speech, but they're really regulating your expressions and your viewpoints. You need to call them on it when they do. You need to call them on it when they do. There are laws right now trying to be passed in almost all 50 states, and eventually will be tried to pass in all 50 states, that regulate your conduct if you have a license. So I have a license to practice law, for example. If I was licensed to practice law in California, where most of the lawyers are, there is a provision in there right now that is saying that you cannot, as a lawyer, engage in speech or words that reflect bias against sexual orientation. Well, the speech I just gave up there earlier today would be enough to have me disbarred in the state of California. Does the First Amendment not matter anymore? Well, how'd they do that? They recharacterize speech and they're calling it conduct.
It's my understanding that the big problem is not teaching the Constitution. The big problem is teaching constitutional law, which is a means by which attorneys learn how to take a little nuanced judgment and apply it to a new situation, and then a judge comes along, expands, and we end up with a whole lot of...
His question is very, very good. His point is that, you know, the problem isn't that we're not teaching constitutional law, is that we're teaching the Constitution, we're teaching constitutional law. In the beginning, this was the law. And unfortunately, when I begin a constitutional law class now, I always start with this, but if I'm going to teach constitutional law, I can't teach the Constitution anymore. Because now constitutional law is no longer what's in this document. Constitutional law is what any 5 justices on any given day say is in this document, and that's wrong.
I was looking through this document that came to us,
Yeah.
and I noticed that county offices aren't on here. And one of the things that I really think we need to do as conservatives who want to get ethical people in office is focus on these county offices where we really can get to our county officials. And the big one that I think relates to Agenda 21 around the state is drain commissioner. There are 83 drain commissioners in the state. They have an extreme amount of power.
Ton of power.
The drain code is a lawyer's playground. Forgive me for saying that, but
right.
It is, you know, and they're using it through the DEQ and the EPA and the drain commissioners who need no experience or education at all, and to take our personal property rights. It's a highly important office.
You know, just think how much power is exercised at that level. And here's from an ethical perspective, here's my concern, is that the higher, when I say higher, I don't mean more important, but the higher you rise in government, you know, state representative, lieutenant governor, the more that the press is watching you. Where the real power that really affects our lives at the township, you know, township supervisors, county commissioners, you know, where's the press on that? You had very little oversight, very little protection from the outside there. So not only is a tremendous amount of power exercised there, but there's a tremendous opportunity for that power to be exercised in a very corrupt way. And so that's another reason why we need good, ethical, and moral conservatives in these positions. But yeah, absolutely. I think your point is right on.
You mentioned that the laws, I guess precedent has established that laws are invalid if their purpose is religious and valid if their purpose is secular.
Yeah.
Is there any merit to the idea of developing an argument that leftism itself is a religion? And could that put the purposes on an equal basis? Although leftism is a satanically informed religion, an evil religion, it's still a religion.
It's a religion. He asked, since you have to have a secular reason for everything under the law now, is there a way that we could argue that, well, secularism is a religion? That's actually been tried. It's such a brilliant idea that it's actually been tried. And of course, if you're the 5 lawyers that want secularism, you're going to say no, and so it was not successful. But I gave this a similar talk to this a while back, and I'm driving to wherever it was, I think it was Grand Rapids, and I'm listening to Fox News of all places, and there had been the inevitable cross that was being argued by the ACLU, or Americans for Separation of Church and State or something. They were saying, hey, you can't have this cross here because it's on government property. And the person on our side that was defending the cross was saying, that cross can absolutely stay there. It's a secular symbol. Look, see, it was given by this secular society. And look at this sign down here. And so we are defending our position using their narrative. It's time we stop that. You know, we don't have to be afraid of serving a living God.
Come on.
Amen.
We don't have to make our arguments fit their narrative. Make their arguments fit our narrative. I challenge our Michigan legislature right now, Republican and Democratic alike, because I don't chase the elephant, I don't chase the donkey, I chase the lamb.
Amen.
To ask themselves the question with regard to funding of Planned Parenthood, you know, what's right and what's wrong here? This is clear. This isn't even a closed question. Now, 5 years from now, this will be a very closely debated question. And people will begin to have their values so coerced that it's not going to be an ugly thing to talk about anymore. It'll be a policy matter for debate. That's the other side, what the other side does, and I'll finish with that. The other side takes something that was a self-evident truth, that thing that was written on your heart, and they say, no, there's no such thing as self-evident truth. It's really a policy matter. If it's a policy matter, now it's something that's up for debate. And it's up for debate, we can, decide whether or not it's right or wrong. And so that's exactly what Planned Parenthood has very effectively done. That's the battle that's going on in Congress right now for the Speaker of the House. Not about who the Speaker is, but will we actually have, just like we have a democratic republic in the election of the representatives, once they get there, will they operate under a dictatorship, or will they operate under a place where they can actually represent their constituents and speak freely without having huge consequences for the party? That's the fight that's going on all over this nation. And at the very bottom, at the foundation of that is an ethical, moral question. What's right and wrong? So that's where I think I'll leave it.